hearing in the appeal, Queen on the application of Gallaher Group Ltd and the Competition and Markets Authority.
Lords, good morning. Can I seek to summarise the submissions I was making yesterday afternoon and then add some points on objective justification and comparability? My Lords, we say the starting point is that the conduct of the OFT in 2008 was plainly a breach of equal treatment and it was grossly unfair. The OFT conferred a benefit on one party to the ERAs, that's TMR, which it did not confer on Gallaher or Summerfield. And that was even though the benefit was inextricably linked to paragraph 7 of the ERA agreement. And it was even though the OFT had assured the parties that they would be given equal treatment. Both courts below, that's Mr. Justice Collins and the Court of Appeal, were satisfied that the conduct of the OFT in 2008 was clearly unfair. Mr. Justice Collins, if I can give your lordships the references, Mr. Justice Collins, paragraph 39, MS238, he uses the words clearly unfair, and also 43, paragraph 43. The Court of Appeal, paragraph 59, where the Court of Appeal say the unequal treatment in 2008 was, quote, stark and manifest. That's MS 221. The question, we say, is not whether it was a wise decision of the OFT in 2008 to give the assurance to TMR. The point is that they did give the assurance. And it was given by the senior responsible OFT officer, Miss Branch. And it was not communicated to us. And we asked this court to begin by agreeing with the lower courts that the conduct of the OFT in 2008 was clearly unfair and it was a breach of the obligation of equal treatment, an obligation they themselves had recognised in principle, and rightly so. That's the first point. The second point we seek to make is that the suggestion that there is an objective justification in 2012 based on the need for legal certainty and finality is, in our submission, unsustainable. There is no dispute that a person who does not appeal has no right to rely on a successful appeal brought by others. That's the wood pulp principle and other cases that the court has seen. However, we say that does not prevent a public body from agreeing to confer on persons who have not appealed the benefit of the appeal decision. I'm very grateful to my Lord Carnworth for recollecting yesterday morning that there is a relevant authority on this subject. Your Lordship referred to a decision by Sir John Donaldson as Master of the Rolls in the context of student grants. And we've got copies with the assistance of your Lordship. Hand up, I've shown this to my friends. This is, we think, the case that my Lord had in mind. It's the Queen against Hertfordshire County Council, ex parte Chung, and it's a decision of the Court of Appeal, Sir John Donaldson, Lord Justice Neal, Lord Justice Balcombe, on the 26th of March 1986. And the context of the judgment is the decision of the Appellate Committee of the House of Lords in December 1982 in the Shah case. Lordships may recall there was a judgment as to the meaning of the concept, statutory concept of ordinarily resident, as a criterion for receipt of a higher education award. And the Appellate Committee restated the law, there's no doubt about that. And the question was how local authorities should deal with students who had been denied grants but now appeared to have been eligible because of the restatement of the criterion. And if your lordships have page 2 of this transcript, the error came to light in December 1982. House of Lords gave judgment in ex parte Shah. Mr. Shah had applied for a similar award a year later in respect of an academic year. His application had been refused on similar grounds, and the grounds are stated in the previous paragraph. The test is a person who's not been ordinarily resident in the UK for the 3 years immediately preceding the first year of the course in question. He lost in all courts below the House of Lords, where the refusal of his application was quashed, and Barnet local authority was ordered to consider his application in accordance with the law as laid down by the Lordship's House. This decision at once created a problem. Mr. Shah was all right, but what about other students whose applications had been refused on the basis of this general misunderstanding of the law, but who had not applied for judicial review? And the department set out a policy statement, which I don't think I need to take time on. I just want to show your lordships the statement of principle by Sir John Donaldson. It's page 4, and it's the penultimate paragraph on page 4. Sir John Donaldson says this. He says, "I wholly accept the proposition that if a test case is in progress in the public law court, others who are in a similar position to the parties should not be expected themselves to begin proceedings in order to protect their positions. I say this for 2 reasons. First, it would strain the resources of the public law court to breaking point. Second, perhaps more important, it's a cardinal principle of good public administration that all persons who are in a similar position should be treated similarly. Accordingly, it could be assumed that the result of the test case would be applied to them by the authorities concerned without the need for proceedings, and that if this did not in the event occur, the court would regard this as a complete justification for a late application for judicial review." Now, that puts the point far higher than I wish to put it, because that statement is, with great respect, not easy to reconcile with the wood pulp provision. It suggests a right to rely on a decision, an appeal decision, even though you have not yourself brought proceedings. And that's not my submission.
Is a possible distinction between a test case situation and a non-test case situation, where there are, in this case, I think, 13
Yes, there were.
Potential
12,
appellants.
There were originally 13. One of them did not have findings made against them, so 12 were left.
12 potential appellants, all or none of whom could either appeal or not appeal, rather than in this case where there's a test case and potentially thousands of students from the country who might be affected by the outcome.
But can I just, grateful for you getting this out. What's always surprised me is that the only statement one can find is a 1986 unreported statement, unsupported by authority. I did look, I don't know if anyone else did, at Smith, where that's in a footnote refers to Chung and then goes on to refer to the O'Brien case. Were you going to look at that?
Indeed.
And says, well, the statement from Lord Bingham that we had yesterday, which is that that fairness, equality is a good thing unless the previous decision was erroneous. So they regard this as consistent with the approach of Lord Bingham in the O'Brien case.
My submission is that matters are more complicated than my friends suggested, in this sense that I do not accept that that a public authority is prohibited from giving an assurance to the subjects of its decisions that if they don't appeal, but an appeal is successfully brought by another, they, the non-appellant, will be given the benefit of the successful appeal. I say it's open to a public authority to adopt that approach, and there may be very good reasons to do that. And I therefore don't accept the implication that in this case, the assurance that was given by the OFT to TMR somehow conflicts with the wood pulp principle.
Well, what it conflicts with is the whole logic of early resolution agreements. The point about early resolution agreements, surely, is that they, in return for a discount, you close the file on that particular case. Now, you can reopen it by appealing, but the risk that you run then is that you will lose the discount. It seems to me that to combine that system with one in which, if other people successfully appeal, you automatically get the benefit of the appeal, means that you get the discount if you are, you basically have a win-win situation, which the whole system is designed to avoid. So it would be irrational, I would have thought, to have both policies simultaneously.
Oh, it wouldn't necessarily be irrational, because the OFT may take the view in a particular case that they want to tie the company concerned into an agreement. They wish to encourage them to.
Well, there may be special reasons for doing it in some cases, but absent special considerations, there is an inconsistency between the kind of assurance that was given and the whole policy underlying ERAs.
Well, that's what makes it so unfair. The unfairness is the consequence of the OFT setting out Clause 7, which is applicable to Gallaher and Summerfield. The OFT saying this is non-negotiable, and then giving a benefit to which undercuts the whole point of Clause 7. So in this case, we say that there's the unfairness in 2008. We do not accept that the principles of finality and certainty would be any more damaged by, in 2012, conferring on Gallaher the same benefit that was conferred on TMR in 2012. The OFT do not adopt the approach in 2012 that this was all a mistake, this was perverse, inexplicable, and therefore we will resile from it. The approach taken by the OFT, deliberately so, is we will reach an agreement with TMR that involves not abandoning the substantive judgment, but paying them back the penalty plus costs. And to confer the same benefit on my clients would be no greater an intrusion into legal certainty and finality than the treatment of TMR in 2012. What the OFT have to justify is that difference of treatment in 2012. And I say that however the matter is put by the OFT, they are seeking to justify the less favourable treatment in 2012 by reference to the unfair treatment in 2008. The case for the OFT as developed in your Lordship's court yesterday is the OFT say that Gallaher and TMR were in a different position in 2012 because TMR had relied on the assurance given in 2008 and we had not. And I say that that purported objective justification is inextricably and impermissibly linked to the breach of equal treatment and the unfairness which occurred in 2008. And our case is that the OFT cannot, in 2012, seek to justify the difference of treatment in 2012 by relying on the OFT's own unfair, unequal conduct in 2008. And that's what the Master of the Rolls found. If we go back, please, to MS 217. It's paragraph 44 of the judgment, 217, where the Court of Appeal addressed the precise point that Mr. Beard, my friend Mr. Beard, is arguing in your Lordship's court. MS 217, paragraph 44, Mr. Beard submits that the appellants were in a materially different position from TMR in 2012 because the appellants did not and could not contend they'd relied on assurances similar to those given to TMR, such as to create a real litigation risk for the OFT, which would justify compromising with them as it did with TMR. This is because absent the assurances, the appellants would have had a weaker case than TMR for establishing exceptional circumstances necessary for the grant of permission to appeal out of time. But as counsel points out, the only reason why the appellants could not have claimed that they relied on assurances of the type given to TMR was because such assurances had not been given to them, and the fact that assurances had been given to TMR was unfairly withheld from them by the OFT. Furthermore, as the court had already held, the failure to give the assurances to the appellants in 2008 was in breach of the obligation to treat all parties fairly and equally. The OFT cannot base an argument that the appellants were not in comparable positions with TMR in 2012 on its failure to treat them fairly and equally in 2008. We respectfully agree. That is the point. Lord Dyson for the Court of Appeal said at paragraph 53, which is on MS 219, and I've read this before, so let me seek to summarise it. He said whether a mistake can provide an objective justification depends on the circumstances. It's not a trump card. And my friend Mr. Beard accepted that in the Court of Appeal, and he accepted it yesterday. It all depends. My submission is that whereas here the circumstances in which the mistaken assurance was given involve substantial unfairness to the complainant, that's in 2008, it is very difficult indeed for the public body to rely on its own mistake, its own unfair mistake, as the basis for an objective justification. And that's what distinguishes this case from other cases, whether it's the tax case, whether it's the Lord Bingham-O'Brien case. The fundamental element of this litigation is the unfairness and the breach of equal treatment in 2008, which the OFT are seeking to rely upon in order to justify the difference of treatment in 2012.
The difficulty is if they'd focused on what had gone wrong or what they'd said in 2008, and they'd said to themselves, what must we do in order to handle this properly, they wouldn't have said, well, the fair thing is now to compound the error and make the same offer to everyone else. They would actually have said, we must unscramble the assurances we've given to TMR. And they would have had to reverse their position. That's the thought which is slightly troubling me about that submission.
But that is the consequence, with great respect to those involved, of their own incompetence. It wasn't just their unfairness in 2008. They had ample opportunity to correct this in 2009 and 2010, as I shall show your lordships. And the question is whether they can, in 2012, seek to plead their own incompetence, their own unfair incompetence, as a justification for the less favourable treatment.
I'm not sure why there is a distinction, as you suggest, between this case and, say, the tax cases, merely because in 2008 the conferring of this advantage upon one of the negotiating parties was unfair. Assume it was unfair for the purposes of this analysis, why is it any less unfair when the revenue mistakenly grants a benefit to a particular taxpayer in 2008, wakes up to what it's done in 2012, and decides no longer to go on compounding that error? It will have been unfair as between that taxpayer and the other ones in 2008 who weren't granted that benefit.
Because whether it is unfair depends on the circumstances of the case. And the tax case, Your Lordship will recall, was a case where there are 100 different tax offices round the country dealing with however many potential taxpayers.
But the fact that it's therefore a sort of postcode lottery, it doesn't make it fair, does it?
No, but it's much easier to see the stark unfairness at the heart of this case, where you have one person, Miss Branch, who is dealing with 12 companies, who has decided to adopt a policy that she will treat all of them equally. And in relation to one of the central terms of the agreement, she decides to confer a benefit on one of those persons and not the other. That is...
No, well, that's not what she decided with respect. She didn't decide that she was going to discriminate in the way that your formulation implies. What she seems to have decided was that in answer to the only person who raised the question, she seems to have expressed a view that she must have thought would apply generally. She wasn't saying, at least the evidence doesn't suggest that she was saying, we must treat these people better than the rest by giving them this insurance which we won't give to the others.
But that's the effect.
It's the effect,
And
but it's not...
The effect is an unfair effect, and it is an unfair effect because she doesn't merely give that assurance to TMR, whatever her intention as to its scope. She fails to communicate that assurance to others. And that's the unfairness.
Well, she would only have reason to communicate it to others if she thought that she was doing something special for TMR.
But she was doing something special. They had asked for a specific assurance as to how the OFT would act in a particular contingency, in a particular event. And that's why the lower courts, both of them, formed the view that the conduct in 2008 was plainly unfair. Your Lordship is putting to me that Your Lordship doesn't accept that the conduct in 2008 was unfair, and I submit...
I'm not disputing that its effect may have been unfair, but there are a large number of cases in which public bodies have had their decisions quashed for setting out a discriminatory policy. This isn't a case about a discriminatory policy. It's a case about a mistaken assumption about what the position was. And there is actually rather an important difference between those when it comes to deciding what is the appropriate thing to do about it.
Well, I can certainly accept that if I could show that Miss Branch was motivated by some wish to confer some special advantage on TMR for some particular reason, my case would be even stronger. But I submit I don't need to go that far. What matters for the purposes of equality of treatment is the effect. And the effect of what she has done, whatever she intended, and it's very murky what she intended because her evidence is extremely unclear as to what she thought at any particular time. But public law doesn't depend upon her intentions. It depends upon the effect of what she has said and what she has done. And that's why all of the private emails that are not communicated cannot be relied upon by the OFT. It's the effect that matters. And if one needs authority for that, I just draw your Lordship's attention to Papinet, the Privy Council case, Volume 2 of the Authorities, tab 16. It's MS 1305, paragraph 30. This is Lord Dyson for the board. The question is how, on a fair reading of the promise, it would have been reasonably understood by those to whom it was made. That's the question.
The point that I'm making to you is simply that this is not a case about a discriminatory policy. It's a case about a breakdown, an accidental breakdown of a non-discriminatory policy.
Yes, it's a case about a breakdown, I submit, a breakdown in fair treatment in all the circumstances that I sought to go through yesterday. I say, and the lower courts accepted, that fairness in 2008 required, given all of the context, that if Miss Branch was to give that type of assurance to one party, she should have told all the others exactly the same as she told them. And that's what the consistency tables suggest. It's what the emails suggest, conferring benefits on one party that had been given to others. And that's the origin of the problem in 2012. Now, it is said against us, we didn't rely on the assurance in 2008. And I've made the point, of course we didn't rely, because unfairly we weren't told about it. But what we did rely on, if reliance matters, what we did rely on were the repeated assurances from the OFT that there would be equal treatment in 2008. And I showed your Lordships the passages in our witness statements, Isabel Taylor, paragraphs 12 and 16. I don't ask the court to get back to it, MS 250 to 251, and the witness statement of Mr. Bingham. This was paragraphs 8, 13, 16 and 20, MS 242 to 245. And the reality of this case is that the OFT was seeking to encourage the parties to enter into ERAs. It was seeking to encourage us to pay over substantial sums of money by way of penalties. And as part of the encouragement from the OFT, it repeatedly assured us and the others that there would be equal treatment, save insofar as the facts of the case differed. Why did we not seek the assurances? The answer is for the reason given in the Statement of Facts and Issues. Your Lordships would go to the Statement of Facts and Issues at MS 85, where the matter is set out very clearly by agreement. MS 85, please. And it's paragraph 31. The OFT took the approach, paragraph 31, the OFT took the approach that the terms set out in the ERA itself would be the same for all the parties, save to the extent that the description in the ERA of the infringements admitted would correspond to the infringements alleged against the party in question. The OFT also made clear to all parties that once one party had agreed early resolution terms, the other parties would be informed of those terms, and those terms would, with the exception just identified, that's facts particular to infringements, be non-negotiable. And that's what we were told. And it's therefore entirely unsurprising that we should not have sought, contrary to TMR, a special side deal. We relied on what we were told, and we were entitled to rely on it. In any event, and I showed your Lordships this yesterday, Papinet, it is not the law that detrimental reliance is an essential element of fairness in a public law context. Perhaps we should just go back to it. It's Papinet, Volume 2 of the Authorities, tab 16.
But does that Does that touch the basic point, which is that even if it's not an essential element, detrimental reliance may be a differentiating factor?
I accept that whether there is detrimental reliance is or can be material, certainly. It's a relevant factor in assessing whether or not an objective justification is shown. My quarrel is with the argument because we did not rely on the assurance, therefore it follows that an objective justification can be established. This was,
I'm not sure the case is...
1305, MS 1305, paragraph 28.
Yes.
The reference you gave us earlier.
I did, yes. And I say, just as reliance is not an essential element of a claim for a legitimate expectation, so similarly, reliance is not an essential element of a claim for equal treatment or for substantial unfairness in public law.
Lord Panic, I don't think I understand the case as being put in quite the way you suggest it is. In other words, I think you may be tilting at a windmill. As I understand the case, in 2012, the OFT really had three alternatives. It could have tried to go back on the effect of the assurance given to TMR while leaving everybody else in the same place, or it could have extended it to everybody else, or it could go back, adhere to the assurance and not extend it to anybody else. And at that point, they say that decision was affected by the fact that there was detrimental reliance by TMR, or rather, that TMR would use detrimental reliance as a reason for getting permission to appeal out of time. So it's only at that stage in the analysis, as I understand it, but I may be wrong, that detrimental reliance comes into the appellant's case.
I entirely accept that, but my answer, my submission, is that the objective justification on which the OFT found their argument is based on the fact that TMR relied on the assurance and my clients did not. And I say that that is an impermissible basis for the objective justification in 2012 because it is inextricably linked to the unfairness, breach of equal treatment of which the OFT was guilty and responsible in 2008. They are simply perpetuating, as against my clients, their own unfairness. And I give that answer on detrimental reliance, whether it's put as part of objective justification or it's put as going to comparability. I mean, the answers are the same. And my friend has, I don't criticise him, but he's various parts of his argument put it on the basis of objective justification, and at other points he's put it as a point going to comparability. But however it's put, it is, I say, inextricably linked to their own unfairness in 2008. There's a further point raised by my friend. He says that Gallaher cannot compare its treatment with that of TMR because the OFT declined to give a similar assurance to Party A in 2009 and to ASDA in 2010. Your Lordships have seen the evidence on that. And that argument, we respectfully submit, is again wrong for the reasons given by Lord Dyson. Lord Dyson deals with this.
Well, these are just other people who, on your case, were discriminated
Yes,
against.
there are other victims.
Yes.
There are other victims.
Yeah.
It goes a bit further because, again, it is simply inexplicable as to why, when the OFT decide, and it's Miss Branch in 2009, it's Mr. Christofides in 2010, because Miss Branch has gone by then, when they decide we're not going to give the assurance to A and to ASDA, why it doesn't click that there's a conflict between those decisions and what they told TMR in 2008?
Well, judging by the lack of attention given to what was said in 2008, I suppose it's quite plausible it simply wasn't in their mind that they'd ever dealt with this problem before.
Well, that, if I may respectfully say so, is a very generous interpretation. Miss Branch is the senior responsible officer who is dealing with 12 parties. She has a particular request made which she answers, and it's put to me by my Lord Sumption that she wasn't conferring some special benefit on TMR. She was stating in 2008 what she understood to be the general position. And yet when...
Well, what she assumed.
What she assumed.
Maybe possibly without thinking very hard.
That is simply inconsistent in my submission with what she then says to Party A in 2009 when she denies them the same benefit. And why this matters is because in 2009, when Party A make the request, and in 2010, when ASDA make the request, we are still in time for notices of appeal. The decision hasn't yet been finalised. That's why A and ASDA are asking this question. And it was therefore open to the OFT, Miss Branch in 2009, Mr. Christofides in 2010, to think, well, this is simply inconsistent with what we've said to TMR, and we'll go back to them. The tobacco decision was not made until 15th of April 2010, and time for appealing expired on the 15th of June 2010. Those are the circumstances of the case. And yet it doesn't occur to the OFT, and there's simply no excuse for what I respectfully submit, and it gives me no pleasure to do so, but I do respectfully submit, it's not just gross unfairness, it's gross incompetence in relation to this matter.
Are we in a position to make any judgment there in the absence of evidence focusing on this point?
Well, the evidence is there, my lord. The evidence is that there's no dispute, indeed the OFT rely upon it, that they, the OFT, through Miss Branch in 2009, are asked by Party A to give the same assurance, very similar assurance, to that given to TMR, and they decide not to do so.
Yes, but as to why they decided not to do so, has that been explored?
No, but it's open to the OFT to provide a credible explanation. And in the absence of any credible, coherent explanation, your lordships are entitled, in my submission, to infer that the OFT, at the very least, was not conducting its activities in a very satisfactory manner. They've had ample opportunity.
We'll probably go that far on this subject.
You can infer that, yes.
Well, I don't think they dispute that.
It would be very difficult for them to do so. I mean, this is a catalogue of errors.
Yes, but
How far?
to go further.
Sorry, I'm sorry. Sorry.
for us to go further, and the evidence seems to me to be extravagant.
No, well, if I'm getting carried away, I withdraw any suggestion your lordship should make findings other than they have not distinguished themselves in the manner in which they have carried out this exercise.
That matter is not in dispute.
No, indeed. And it is surprising. I would go this far. It is surprising. And it calls for an explanation as to why they don't go back to TMR. And no explanation has been given. I
just wondered how far these things had been probed in front of Mr. Justice Collins, two-day hearing, but...
well, there's no oral evidence. This is all on affidavit.
No, and you were there, though.
I emphasise it's the case for OFT. They raise as a point in their favour the fact that the assurance was not given in 2009, 2010 to Party A and to ASDA. And I respond that doesn't help them, and I respond that the failure then to go back to TMR is yet another indication of just how unfair and how inappropriate their conduct was throughout this saga. Now, do any of the authorities assist the CMA? I do not accept that the speech of Lord Bingham for the Appellate Committee in the O'Brien case assists them. This was Authorities Volume 2, tab 22. This was the independent assessor.
Page?
As MS 1490. My lord.
Thank you.
Authorities Volume 2, tab 22, 1490. In particular, attention has been drawn to paragraph 30. It's generally, this is 1506, MS 1506. It's generally desirable decision makers, whether administrative or judicial, should act in a broadly consistent manner. If they do, reasonable hopes will not be disappointed. But the assessor's task in this case was to assess fair compensation for each of the appellants. He was not entitled to award more or less than in his considered judgment they deserved. He wasn't bound, and in my opinion was not entitled to follow a previous decision which he considered erroneous, in which would yield what he judged to be an excessive award. Now, I don't quarrel with any of that, but it's in the context of a quasi-judicial assessment where the assessor has no duty to follow a decision of a different assessor, which the assessor considers erroneous. The case involves no conspicuous unfairness, no unfairness of any sort. By contrast, I say this case was a case where Miss Branch was obliged in 2008. Indeed, she recognised she was obliged to act consistently and treat each of the 12 companies. That was their policy. That's what they promised. So O'Brien doesn't assist, my friends, nor do the other cases on which they rely, including the Qualifications Authority case that my friend took your lordships to. Each of those cases depends on their individual facts as to whether there was unfairness, and none of them dispute that in a case of unfairness, then objective justification cannot be established. The Commissioner for Customs and Excise case, which I've already mentioned in answer to my Lord Briggs, was Authorities Volume 1, tab 6, MS 961. And your lordships will recall this is the judgment of Mr. Justice Jacob, and the claimant had unsuccessfully sought repayment of VAT overpayments, and the relevant tax office had chosen to invoke an unjust enrichment defence. It's a defence under section 80, subsection 3 of the legislation. And the taxpayer's point was that other tax offices had allowed similar claims for repayment. They'd not invoked the statutory defence. And it was in that context that the taxpayer complained of unequal treatment. And at the time, see paragraph 42, this is MS 973, paragraph 42, there were over 100 tax offices. Each dealt with overpayment claims broadly independently. Now, I don't in any way dispute the conclusion of Mr. Justice Jacob. It's an obiter conclusion, because he previously decided that the tribunal and therefore the court had no jurisdiction over this argument of a lack of equal treatment. But I don't dispute his obiter conclusion that on the facts of that case, the taxpayer could not sustain an argument that he was the victim of a breach of equal treatment. The unfairness to that taxpayer was very slight indeed, if any. He had no expectation that he would be treated equally with other taxpayers. There was no promise to that effect.
I'm a taxpayer. I hope I have an expectation of equal treatment.
Yes, well, in Fleet Street Casuals, it's quite clear that HMRC are under a duty of fairness towards the taxpayers. And certainly, in my experience, when I used to assist HMRC in their cases, was that that was a duty which was taken very seriously, and the taxpayer expected it to be.
But he had no expectation that in his case the revenue were not going to rely upon the unjust enrichment statutory provision which denied him any entitlement to the claim. And we're not dealing in this context with a small number of persons in respect of whom a public authority, this branch, is promising that there will be equal treatment in the context of an agreement where an assurance is given to one party which fundamentally undermines clause 7 of the agreement. The context is entirely different. And I therefore do not accept that the judgment of Mr. Justice Jacob, as the Court of Appeal said in this case, could possibly be authority for the proposition that a mistake is always the basis for an objective justification for a difference of treatment. It all depends.
I don't think anyone's disputing that, is it? Are they? As I understand Mr. Beard's position, he doesn't assert
Indeed.
that it is a trump card. He says it depends on the circumstances.
Exactly.
And you can fairly say, well, NatWest is a very different circumstance.
Well, that's my submission.
Yes.
That's my submission. And that's why I don't quarrel with the conclusion in that case. I don't need to quarrel with the conclusion in that case. Indeed, I would go this far that the court would want to be satisfied that there is unfairness before it concludes that a mistake cannot form the basis of an objective justification. I'm not inviting your lordships to declare open season on public authorities. So my submission, if I may seek to bring the threads together, we say that Lord Dyson was correct at paragraph 53 of the judgment, MS 219, and as my friend accepted in the Court of Appeal, and he accepts here, as my Lord Hodge points out, that the fact that the treatment of another was a mistake may or may not provide an objective justification for the difference in treatment. It all depends. And we submit that in the circumstances of this case, the OFT cannot justify its conduct in 2012 by saying we made a mistake in 2008. And that's for these reasons, just to summarise my submissions. First, I say the conduct of the OFT in 2008 was, as both lower courts held, a plain breach of equal treatment and obviously unfair. Miss Branch did not just make a minor error. She acted in a way which was fundamentally incompatible with the policy adopted by the OFT in relation to ERAs, with the assurances that had been given to the parties, by not communicating to us an assurance given to TMR in relation to a matter vital to clause 7 of the ERA. That's the first point. The second point is that this assurance and this unfairness in 2008 was the responsibility of the most senior OFT official in charge, as she has described herself, of the ERA process. Thirdly, we draw attention to the circumstances of 2009-2010, where despite the decision not to confer a similar assurance on Party A and ASDA, Miss Branch and then Mr. Christofides take no action in relation to the assurance that had been given to TMR. And that's despite it being put to me, for the purposes of argument, that the approach of Miss Branch in 2008 was that she was giving a general assurance, not specific to anything relating to TMR. And fourthly, we emphasise, we say this is highly material, and again it's a contrast with the judgment of Mr. Justice Jacob. Gallaher is not seeking a windfall here. I invite your lordships not to forget that the substantive decision of the OFT was an unlawful one.
That's a slightly difficult area, isn't it? Because it doesn't actually lie, does it, in your client's mouth to assert that, because it's binding on them. I mean, we may be told and we may see that in a different scenario it wouldn't bind you. But it's a bit difficult for you to say it's unlawful and you're bound by it.
I recognise the sensitivity of the point, but I do say that the court should not be blind, with great respect, to the realities of this case. And in the judgment of Mr. Justice Jacob, the taxpayer is seeking something which the law on its substance did not entitle him to receive. And if your lordships are weighing up whether or not there is an objective justification, it is a factor that, as a result of the assurance given in 2008, but not given to us, and the assurances of equal treatment which have been designed to encourage us to enter into the ERA, the result is that we have paid over a very substantial sum of money in relation to a decision of the OFT which has been found, in general terms, has been found not to be lawful. And my Lord Sumption asked my friend yesterday morning whether, if Gallaher and Summerfield had appealed, there would have been any basis for the OFT to distinguish their cases. And my friend very fairly and properly and accurately said no. Now, I recognise, of course, that we didn't appeal, but when your lordships are looking at objective justification, it is a factor that may be relevant and is relevant, my submission.
And I suppose you can say, to my point, that it was precisely that scenario that the assurance was meeting, namely a decision which it could now be seen shouldn't have been made, because I suppose it can hardly be contemplated that the assurance would have applied, could it, if the decision was set aside on grounds which didn't necessarily apply against TMR? I mean, maybe in this case it was always obvious that it was all or nothing, but I don't know. But
that complication doesn't arise.
Doesn't arise, but I mean, if one asks oneself what was the assurance given to TMR, it must surely have been given on the basis that it was inevitable that if the decision was set aside at all, this was something that was going to benefit everyone. Yes. So you can batten on that. The assurance was precisely covering this situation.
Well, that's how we put it. But Lords, I recognise, well, it would not be realistic for me not to recognise that a court is reluctant to allow a party to piggyback, as it is put against us, on what is said to have been a mistake in the OFT's treatment of TMR. But I urge upon your lordships that whether the OFT can be allowed to rely upon their own mistake must depend upon the fairness of the case in all the circumstances. And I emphasise that whenever a person relies on the principle of equal treatment, or indeed on the principle of substantive unfairness, he is seeking a benefit to which he otherwise has no legal entitlement. That's the whole point of the doctrine of equal treatment. It's the whole point of the principle of substantive unfairness. If we had a legal entitlement, we would not need to rely on equal treatment or on substantive unfairness. And the law recognises these principles, the principle of equal treatment and the principle of no substantive unfairness, because they make an important contribution themselves to legal certainty and to the rule of law. And my friend does not dispute that the law imposes limits on the extent to which a public body can rely on its own mistake as a justification for a difference of treatment. My submission is that the unfairness in this case is such. The breaches of policy, breaches of assurances, the conflict with paragraph 7 of the agreement are such that the court should not accept the OFT's purported justification based on its own mistakes, 2008, 2009, 2010. And it's for those reasons, subject to any questions your lordships may have for me, it's for those reasons we are inviting your lordships to dismiss this appeal.
Thank you very much.
Thank you very much.
Mr. Musa.
My lord.
Thank you very much. Yes, Miss Blythe.
My Lords, we gratefully adopt Lord Pannick's submissions on behalf of Gallaher. What I propose to do is briefly highlight the relevant facts as regards Summerfield, and then say a couple of things about objective justification. As regards the relevant facts, we say, in short, that what goes for Gallaher goes for Summerfield. As in the case of Gallaher, the OFT's officers made statements to Summerfield to the effect that the OFT would apply the principles of equal treatment. And those statements, of course, reflected the speaking note and the principled approach to settlements document that Lord Pannick has already shown you. The OFT made such statements to Summerfield in the first early resolution meeting of the 22nd of May 2008. Summerfield's note of that meeting is at electronic bundle page 339. See, at the beginning of the first substantive paragraph, the OFT began by introducing the proceedings and confirming that these will be the same for all parties to an early resolution agreement. And turning over the page, 5 paragraphs down, once an early resolution agreement has been signed, the basis on which the agreement has been made will limit negotiations with other parties. The reason for this is the principle of equal treatment. For this reason, the discount for mitigation will be the same for each party qualifying under a specific point or heading of mitigation. It also made such statements at the subsequent meeting on the 26th of June 2008. And the OFT's note of that meeting is at electronic bundle page number 582. That's in part 2 of the appendix to the Statement of Facts and Issues. My Lords don't have a hard copy of part 2.
Sorry, 582.
582. Context here, if if you turn on to the second page, there's a heading IIC, and the context was that Summerfield took the strong view that the OFT had
Sorry, can
no
you give me a
evidence-
reference to the appendix to the Statement of Facts and
it's
Issues?
Appendix Part 2, page 380. 379 is where the document begins.
What, 26th of June?
That's right. One of Summerfield's concerns at this stage was that there was an allegation of information sharing, which Summerfield felt simply was not evidenced in its own case. And on the second page of this note, you can see under the heading IIC, if you look at the second paragraph, BH, that's William Hull, who was acting for Summerfield, says that he is aware of the bright line distinction, but that Summerfield was not keen to admit something they haven't done. LC replied that the project team had considered the material that Summerfield submitted and admitted that an inference was drawn. LC, that's Mr. Christophides, added that Summerfield were correct to conclude that the OFD does not have any positive evidence of communication and that the project team have gone through the documents on the file and understand the points Summerfield are making. In order to treat all parties equally, LC stated that the project team were happy to discuss any manifest errors of law or fact. They would not be able to discuss arguable points, either strong or weak ones. And then if you look at the top of the next page, BH replied that Summerfield were asked to admit something that they believed they didn't do. They agreed with the arguments put forth by the project team, except for IIC. BH added that Summerfield would like to continue with EI, but wasn't sure what else he could do to disprove the OFT's IIC argument. SB stated that Summerfield could either admit to all the alleged infringements or deny them all, but a bright line distinction needed to be maintained. LC added that there were two other parties involved in this particular infringement with Summerfield, and that if either of them provided information supporting Summerfield's point, Summerfield would receive its benefit.
Just remind me what IIC stands for.
Indirect illegitimate contact.
Nice.
So the point there was that the OFT were saying that the principle of equal treatment was being applied very strictly. There was no scope for Summerfield to negotiate an exception in respect of the IIC allegation, even though the OFT could see Summerfield's point about the evidence. The reason given for that was the need to treat everyone equally, but at the same time, the OFT was saying...
I find the reasoning a bit odd. Why do you have to admit all the alleged infringements or deny them all? Why shouldn't you say, well, in fact, I only admit some of them?
Well, my lord, it was the position the OFT took, that what went for one was going to go for all in this case.
I know, but it seems to be particularly illogical on this area, when the argument is as to what you've done. There must be possible to have some people who participated to some extent and not others.
Well, it simply underlines the point that the strong message was that there was no scope for individual negotiation of individual concessions, even in a strong case.
Well, the allegation was that a general information sharing arrangement across all the parties, and if it wasn't true of any one of the parties, that was undermined in relation to the others as well. Since that was the OFT's assertion, it's not perhaps terribly surprising that they took that line.
It's a sort of Procrustean bed.
Well, there's an element of that in any conspiracy allegation, where some people do some aspects of the conspiracy, others do others, to a shared end.
Yes, I see.
In the event,
Anyway, you've got
in the event, the OFT dropped the IIC infringement. But at this stage, in the negotiation stage, it was saying it's everything or nothing. But it was also saying that if someone else is able to persuade us otherwise, then we will treat you in the same way.
They dropped the information sharing allegation generally, didn't they? Not just in relation to your clients.
Yes, indeed. And as in the case of Gallaher, the commitment to equal treatment was reflected in his conduct towards Summerfield during the early resolution process. So on the 9th of June 2008, Summerfield was told that its penalty would be reduced as a result of discussions with the tobacco manufacturer, and a reduced penalty figure was then duly put forward, the OFTs, I don't ask you to turn up Mr. Hull's witness statement, which deals with this at paragraphs 20 to 23, but there's an OFT note of the call, which is in part 2 of the appendix, electronic page number 557, and appendix 2, page 354. That's a note of a telephone conversation with Nicola Kingsby to Summerfield on the 9th of June. I rang NK to update her on progress with early resolution discussions. I explained that I would be sending a revised proposed penalty that would include the following amendments. I said that the first change corresponded to that adopted as part of an agreement in principle that had been reached with the manufacturer. The second change had been made following representations from another party. Then on the 24th of June, the OFT sent Summerfield a draft PRA, stating in the covering letter that this was non-negotiable because it reflected the position reached with another party, and that party was Gallaher. And the covering letter is at page 568 of the electronic bundle, appendix 2, page 365. So you see there's a sentence, the draft reflects the position we have reached in discussions with the party, which we have reached as an agreement in principle and is therefore non-negotiable. And if you look at the draft agreement, you can see it includes clause 7, which was the clause concerned with imposing burden or risk on someone who entered into settlement and subsequently appealed. So that was one of the terms that was being stated to be non-negotiable. And in those circumstances, it's not surprising that Summerfield, like Gallaher, understood it not to be up for negotiation, that a non-appellant would not have the benefit automatically of a successful appeal by a third party. On the 26th of June, the OFT agreed to reduce Summerfield's penalty in accordance with a number of adjustments that were argued for by Summerfield, but it made clear that those adjustments would be applied to all parties, and the evidence for that is Mr. Hull's witness statement at paragraph 27, electronic bundle, page 262, but I don't ask you to turn it up. And then on the 4th of July, Summerfield spoke to the OFT again about the ER procedure, and Mr. Christofides stated in that conversation that the OFT could not reduce Summerfield's penalty by an amount represented by the IIC infringement on the grounds of equal treatment. And the evidence of that is Mr. Hull's witness statement at paragraph 30. So again, that's continuing the theme of the IIC infringement about which Summerfield felt particularly aggrieved. And again, the reason given for not budging was equal treatment as between parties.
You have a page reference for that?
It's in the evidence of Mr. Hull, which is electronic bundle, page 262 to 263.
Appendix 157, is it? Yes, 255, 262 to 3. Right.
Yes, and it's paragraph 30 of his statement there. On 4th of July, I spoke again with the OFT. Mr. Christofides told me that he was responding on behalf of Ms. Branch in relation to Summerfield's continued concerns in being asked to admit liability in respect of the IIC, in circumstances where Summerfield believed that in its entirety the evidence before the OFT showed strongly that there had been no IIC infringement of allegedly SO and SSO. And then further on in that paragraph, Mr. Christofides told me that on grounds of equal treatment, the OFT considered that it was not able to reduce Summerfield's penalty by the amount represented by the IIC infringement without going through this process, and that was a process of making allegations of factual inaccuracies in the statement of objections. So Mr. Christofides was taking Summerfield's point, but saying on grounds of equal treatment, we can't budge on the terms of the settlement. So, like Gallaher, we say Summerfield was consistently given the impression that there was no room in the process for the negotiation of individual concessions. Like Gallaher, Summerfield was not aware of the assurances that had been provided to TM Retail and didn't consider that assurance of that sort would be available. And there's evidence to that effect in Mr. Hull's witness statement at paragraphs 38 and 41, which is electronic bundles, page 265 to 266. But that's not surprising in any event, because, as I've said, the draft agreement contained clause 7. And like Gallaher, finally, we say it's highly likely that Summerfield would have asked for such assurances if it knew that they'd been provided to another party. Mr. Hull's evidence on that is at paragraph 41 of his witness statement, but it's in any event self-evident, we say, for the reason given by my Lord Mance yesterday, which is that it puts the recipient of those assurances in a win-win situation. So those are the relevant facts about Summerfield. My remaining points relate to the CMA's argument on objective justification. The burden of the CMA's case in this regard is that unequal treatment of Summerfield and Gallaher is justified, or was justified, because extending the TMR benefits to them would constitute the replication of a decision based on a mistake. Mr. Beard relies on a principle that there is a strong public interest in the non-replication of mistakes by public bodies, which, while not a trump card, he says, can only be defeated by conspicuous unfairness. And he's said that that is axiomatic to the proper rule of law. Our submission is that that has to be overstated, even setting aside questions of fairness. The strength of the public interest in the non-replication of any particular mistake by a public body is going to depend on the circumstances, including the nature and significance of the mistake, the number of people to whom it's potentially replicable, and any public interests that may pull in the opposite direction. And that's setting aside questions of fairness, so we don't accept that the question of conspicuous unfairness is the only question that's relevant when considering whether a mistake ought to be or ought not to be replicated. There's a difference between saying that the fact that there has been a mistake is itself always a justification for not treating others in the same way, absent conspicuous unfairness, which I understand to be Mr. Beard's position, and saying that where there has been a mistake, consistent treatment is not necessarily required unless there is conspicuous unfairness.
Sorry, say it. The distinction is between... say it again.
So
it comes rather fine.
Between saying that the fact that there has been a mistake is itself always a justification for not treating others in the same way unless there is conspicuous unfairness. So if that's the position, then the only thing relevant, if you've established a mistake, the only thing relevant is conspicuous unfairness. Yes. Whereas the correct position on the authority, as we say, is that where there has been a mistake, consistent treatment is not necessarily required unless there is conspicuous unfairness. So all the circumstances are relevant.
Which is the best authority from your point of view to establish that proposition?
Well, what I say is that the authorities that Mr. Beard took you to yesterday support the latter proposition and not the former. So the first was O'Brien. I'm not going to ask you to turn up paragraph 30 again. I'm sure everyone has it well in mind. But the key point in that case was that the statutory scheme required the assessors to assess for themselves fair compensation.
Yeah.
Now, in those circumstances, it's obvious that a subsequent assessor would not be entitled to replicate errors of previous assessors if he believed them to be errors, because he's got an obligation under the statute to look at it himself. But that doesn't establish a general principle that errors should never be replicated unless there's conspicuous unfairness. The second case he took you to is the AQA case, and that's at Authorities Bundle 2, tab 20. The one about the grade boundaries for exam marks. And again, it's page 1424.
1424. Thank you.
So we say that case doesn't espouse any principle that mistakes may only be replicated in cases of conspicuous unfairness. Look at paragraph 124 of that
MS number, please.
MS number 1451.
Thank you.
It was the particular circumstances that supported the conclusion that the mistake ought not to be replicated. In paragraph 124, in my judgment, maintaining the currency, this is Lord Justice Elias, maintaining the currency of the qualification was a powerful and legitimate justification in the public interest, even though it involved accepting as a necessary, albeit highly undesirable consequence that the June students were to some extent subject to tougher assessments than their January and indeed earlier counterparts. This is particularly so given the fact that those benefiting from the over-generous grading in January were a relatively small contingent when compared with the June cohort. That was especially true in relation to the boundary change most strongly challenged in this case. If Ofqual had not brought a halt to the inconsistent standards at this stage, they would have had to have done so at a later stage until they were prepared to forego their principal objective and debase the value of the currency of the English GCSE. The key consideration was that perpetuating the mistake in that case would have diluted the currency of the qualification and would have to be replicated to a large number.
What about the Tate and Lyle case? Does that help?
I'm sorry, my lord, I didn't...
He refers to the Tate and Lyle case.
He does. He also refers to O'Brien, and you can see that the principle he takes, so paragraph 125, the principle he takes from O'Brien is not that mistakes ought never to be replicated unless there's conspicuous unfairness. The final sentence of paragraph 126, what he takes from O'Brien, is that there is nothing inherently unfair in putting right earlier errors rather than compounding them, even if this involves creating a disparity between similarly placed individuals. So again, the principle...
You accept that principle?
Yes, we accept that principle.
And is Tate and Lyle an example of that? Because that seems again to be a sort of case where some people are apparently in similar positions. One's getting a windfall, which probably shouldn't have got. But that doesn't mean everyone has to have the windfall.
My lord, that may be right.
Is there a sort of legally right or wrong answer in every situation where a public authority is faced with the unenviable alternative of either one, replicating a mistake, or two, treating people who are in comparable positions differently? Or
Well, it will depend, my lord, on the circumstances.
No, but my question is this a sort of situation where there's one legally right or wrong answer, or does the public authority have some, to use a probably inappropriate phrase, margin of appreciation in its choice?
My lord, I think the latter probably must be the case.
That's because you're balancing a range of factors which
Indeed.
you might weigh differently.
Indeed. And it will depend on the circumstances. And returning finally to Nat West, which is Authorities Bundle 1, tab 6, MS page 961. Turning to paragraph 66, the final sentence of that paragraph, which is what Mr. Beard relies on. Again, you can see how the principle is put. It is entirely within the...
Sorry, what page is
66
66 on?
MS 976,
Yes.
paragraph 66. It appears to me to be entirely within the ambit of objective justification to say that mistakes need not be perpetuated, and to take into account the fact what is involved here is both complex law and a necessarily large administrative system. So again, the principle is that where there's a mistake, you don't need to perpetuate the mistake, but that the circumstances are relevant, and he identifies there two circumstances relevant to the question whether in this case the mistake ought to be perpetuated, i.e. Consistent treatment ought to be preferred or not. And again, in paragraph 64, he says a number of wrongs do not necessarily make a right. And again, I emphasise the word necessarily because it suggests a recognition that a number of wrongs may make a mistake. It just depends on the circumstances. So that is essentially what I've just submitted is essentially what the Court of Appeal found at paragraph 53 of its judgment in the final sentence that Lord Panic directed you to a moment ago. The fact that there has been a mistake may be an important circumstance, it may be decisive, it all depends. And we submit that's correct, which is to say that merely characterising something that an authority has done as a mistake of some sort doesn't in itself take you very far in considering whether the public interest favours the replication of the mistake or the non-replication of the mistake. So in the present case, we say, examining the circumstances, although the assurances to TMR may be characterised as in some sense a mistake, there's no overriding public interest here in a mistake of this sort in all the circumstances not being replicated. The first relevant circumstance is the small number of parties to whom the decision to give TMR those assurances might in principle be replicated, and that is relevant to the strength of the public interest in non-replication. There were only 5 ER parties who did not appeal, and in respect of whom the TMR benefit could in principle have been replicated. So this is not a case where replication would have resulted in incalculable costs or consequences or would have had implications for a large or innominate group of people. And that was a point made by the Court of Appeal in its judgment at paragraph 57, which is MS page number 220. The final sentence of that paragraph, it is relevant to what overall fairness requires to make an assessment of the effect of an error and its replication. We see this in play in cases concerning substantive legitimate expectation and quotes Begbie. In other cases, the act or omission complained of may take place on a much smaller scale with far fewer players. Here, with respect, lies the importance of the fact in the Cochran case. The case's facts will be discrete and limited, having no implications for a nominate class of persons. There may be no wide-ranging issues of general policy, or none with multi-layered effects upon whose merit the court is asked to embark. The court may be able to envisage clearly and with sufficient certainty what the full consequences may be of any order it makes. In such a case, the court's condemnation of what is done as an abuse of power, justifiable, or rather failing to be relieved of its character as abusive only if an overriding public interest is shown of which the court is the judge, offers no offence to the claims of democratic power. We say that's this case. There were only a few people involved. There are no wider implications. And that's relevant when assessing the strength of the purported public interest in the mistake not being replicated. Yeah. Second relevant circumstance is the type of mistake that is in issue here. This has already been traversed to some extent, and it's not entirely easy to pin down the sense in which the assurances to TMR can be said to have been a mistake. They were not mistaken in the sense of simply communicating an erroneous statement of law. We rely in that regard on paragraph 32 of the Court of Appeal's analysis at Electronic Bundle 214. But I don't need to go there. It's already been considered. Mr. Morris was obviously not asking to be told on behalf of his clients what the law says about non-appellants. He would have been in a position to advise his own clients about that. He was asking on behalf of his clients what the OFT would do as regards non-appellants. And in response, TMR was given to understand that what the OFT would do was vary or withdraw the decision. As Lord Panic has said, it has not been the CMA's case in these proceedings that is something the OFT had no vires to promise. The assurances are said by the CMA to be mistaken in the sense of being inconsistent with Wood Pulp 2 or based on a misunderstanding of the law in that domain and associated case law. But Wood Pulp 2 is concerned with whether a public authority is required to re-examine decisions against non-appellants in the light of successful appeals, not whether a public authority is entitled to do so, and still less whether it may sometimes be permissible or advisable for it to do so for reasons of policy. So, for that reason, we do not accept that the assurances were mistaken in the sense of being inconsistent with Wood Pulp 2. I'll just take you to the relevant passages in Wood Pulp 2, which is at Authorities Bundle 3, tab 34, electronic bundle number 1913, and turning to paragraph 63 at 1930, where a number of similar individual decisions imposing fines have been adopted pursuant to a common procedure, and only some addressees have taken legal action against the decisions concerning them and obtained their annulment, the principle of legal certainty underlying the explanation set forth in paragraphs 57 to 56 of the above therefore precludes any necessity for the institution which adopted the decisions to re-examine at the request of other addressees in the light of the grounds of the annulling judgment the legality of the unchallenged decisions, and to determine on the basis of that examination whether the fines paid must be refunded. And similarly, paragraph 71, the Court of First Instance erred in law in holding that Article 176 of the treaty placed the Commission under the duty to re-examine at the request of those concerned the legality of the Wood Pulp decision, insofar as it concerned them. My Lord Sumption suggested, I think, that the assurances may have been a mistake in the sense of expressing a mistaken belief on Ms. Branch's part that withdrawal or variation was what TMR would be entitled to in the case of a successful third-party appeal. But Ms. Branch's evidence is not to that effect. If I can direct you to electronic bundle page 297, paragraph 63, she says, I do not specifically recall why I gave TM Retail a broadly positive response, as opposed to indicating that the OFT would not extend to it the benefit of the successful appeal, which at the time I felt could realistically only have been a penalty. Doing my best to reconstruct my thinking now, I believe my brief response would have been based on a broad sense that, in the hypothetical event of the tribunal deciding there were errors in the OFT's approach to the penalty calculations for the successful appellants, it might be considered to be the appropriate reaction for the OFT as a public body to make corresponding adjustments for ER parties. So she clearly is talking there about the OFT exercising a discretion. She doesn't suggest, her view was that TM Retail would have been entitled to this.
Why do you say discretion? Because of the words, it might be considered to be the appropriate reaction.
Yes, because of those words.
I mean, well, surely all that she's saying is that it might be appropriate generally. She's not saying that there would be a discretion to, so to speak, do it in some cases but not others.
No, isn't she suggesting that this was her guess as to what the right position was?
Yeah.
The right position, but not the right position as a matter of law. She doesn't say...
Well, the right position is a matter of administrative practice. I mean, it's at this stage one tends not to think of it in terms of legal obligation, but of appropriate administrative behaviour.
It's not about what TMR was entitled to. That was not her thought. And it is in any event hard to believe that Ms. Branch would have held the mistaken view that TMR would be entitled to reap the benefit of another party's appeal without appealing, since that would have undermined the point of Clause 7 of the ERA, which was a non-negotiable term.
Why was she agreeing it? Why was she agreeing it at all? A weak negotiating position, so she felt she had to give away things to which they were not entitled?
She was desperate to get them to sign up, to get as many as possible to sign up. And there's evidence in her statement to the effect of that the OFT was very keen to conclude settlements with as many people as possible, ideally with everyone.
Well, that's not something you can extract from her witness statements.
The natural keenness to settle what would otherwise be very lengthy and expensive litigation isn't quite the same as desperation.
I was asked by my Lord Mance why she did it. That was an invitation to speculate.
No, I think your answer was the question.
That's what I did.
As a matter of evidence. Well, she was...
But we say it is in fact in her witness statement that their absolutely key objective was to
Yes.
include settlements with as many people as possible. So speculating as to what I mean, she is not able to recollect what caused her to say it specifically. She's reconstructing her own reasoning, but speculating as to why someone in her position in those circumstances might have said something like that.
I mean, to go back to your basic point, that to treat this as a situation where a public authority has a discretion whether to refund seems a bit odd if one accepts, or once one accepts, that the whole purpose of the whole rationale of the wood pulp principle is certainty, finality, and once you make a decision and decide not to appeal, and in particular, once you get the benefit of a settlement, the assurance given would, on the face of it, undermine all that. But leaving aside an assurance, would there be just a discretion to return? I rather doubt it. I think it would be contrary to the public authority's function in the absence of an assurance to simply to return, wouldn't it?
Well, my lord, that may be so in the absence of an assurance.
Yes,
But that doesn't mean that it's...
I agree. I mean, the whole of the case before us turns on the fact that assurance was given to one party and unfairly not given to others. That's the case, and so it's not the situation I'm postulating. But you were suggesting this is some general discretionary situation. I thought.
I wasn't intending to suggest that, my lord, no.
Right.
On the other hand, we don't accept that the assurances were mistaken in the sense of having been necessarily irrational, having regard to considerations of legal certainty and finality, or, as my Lord Sumption put it today, contrary to the logic of the ERAs. Because one point is that legal certainty and finality, they're obviously important, but they are not paramount considerations in every circumstance. And Parliament itself has
accept that they were inconsistent with Clause 7 of the ERA?
The assurances, yes, inconsistent with the spirit of Clause 7 of the ERA.
Well, and not just the spirit, I mean.
Indeed, but the question here is in what sense were they a mistake of a sort that generates a strong public interest in their not being replicated? And Mr. Beard relies on legal certainty and finality as creating that strong public interest. And that would be so if it was obviously irrational to make the assurances having regard to considerations of legal certainty and finality. But we say that isn't so. Parliament itself has recognised that legal certainty and finality may be compromised in the interest of justice. That's why there's provision for an out-of-time appeal in exceptional circumstances. And there's in our submission no basis for a suggestion that an enforcement body could never rationally make a promise of this sort in order to induce settlement if it considered that settlement was overridingly in the public interest, if, for instance, it perceived that the potential damage to legal certainty was very small, because, as in this case, it thinks the chances of a successful appeal are vanishingly small, or if it thinks that by offering such a promise, it will be able to induce all parties to settle. I mean, it's not inconceivable. So what we say is that the only sense in which the assurances to TM Retail were a mistake on analysis and on the evidence is that they were made without adequate consideration. They constituted a gratuitous promise which, having regard to considerations of legal certainty and finality, the CMA later considered it ought not to have made. But we say that the fact that they may have been mistaken in that sense doesn't mean that there is a strong public interest in the assurances not being replicated to a small group of people concerned against a background of assurances of equal treatment. Indeed, for it to be accepted by this court that an authority ought never to be held to a mistake of this sort, absent conspicuous unfairness, would create some strange incentives, because public authorities...
I don't think that's the submission being made. I mean, again and again, the appellants are saying that replication of a mistake is a trump card.
They're not saying it's a trump card because they accept that conspicuous unfairness can justify replication of a mistake.
Well, that's such an elastic concept that what it amounts to saying is, well, it all depends on the circumstances, which is what everybody, including you, has been saying.
Yes, the only thing I would add is that it is not restricted to circumstances that may be relevant to fairness. It's
Yes,
the public-
your
the
point
public
is the
interest
weight
goes
of
broader.
public interest forces the court to take into account, among other things, the fact that only 5 companies are involved, not a multitude. Yes.
And briefly, the third feature that I say is relevant when considering the balance of that public interest is the public interests that pull in the other direction. Not only the public interest in consistency and equal treatment, which in this case were valuable not only in themselves but also because the OFT identified them as being integral to an effective settlement process, i.e. in the OFT's own administrative regulatory interests. There's also a strong public interest in authorities doing what they promise and being held to account. And can I turn up Papanet at MS page 1307, which is in Authorities Bundle 2.
Is this Papanet?
Yes, and I just wanted to refer to the quotation from...
Sorry, which page?
It's page 1307, paragraph 38. And what I draw attention to is a quotation from Nadaraja, principle from Criminal Justice Laws. The principle that good administration requires public authorities to be held to their promises would be undermined if the law did not insist that any failure or refusal to comply is objectively justified as a proportionate measure in the circumstances.
But in this case, they didn't refuse to comply with their promise. They just didn't make a promise to your client.
Well, they made a promise of equal treatment,
Yes.
with which they failed to comply. And the point I take from that quotation is that the requirement of objective justification is identified as a requirement that safeguards the value of good administration. Now, it could not do so if the test of objective justification could be satisfied by the fact that the authority had committed a blunder, because that per se is contrary to good administration.
I mean, it's a one-way horse, isn't it, this? Because if you had a situation where they'd actually treated other people worse than you, it's quite obvious that this principle wouldn't be relied on. You were treated better. They were treated better, but in a way which was the last thing that you expected to be treated.
Accept that, my lord.
We've got a lot of factors to balance here.
Indeed.
Query, I mean, how far, if this is a balancing exercise and if there is a degree of flexibility in the right result, then what do you say about the conflicting decisions below? So Mr. Justice Collins can be discarded because it was too simple, and the Court of Appeal is more sophisticated and thorough.
The Court of Appeal found manifest unfairness in the facts. So,
Yes, the Court of Appeal placed huge weight on what you and Lord Panic have both stressed, which is that the importance of holding people to their promises.
Yes, but so I say that the factors that were considered important, whether or not they establish conspicuous unfairness, are relevant to the question whether the mistake ought to have been perpetuated, and support the conclusion that there was no strong public interest in the mistake of this sort in these circumstances being replicated.
Being replicated or corrected?
Well, I think it's put in terms of replication, but...
Yes,
but,
yes, quite. Yes,
yes.
Sorry, I was looking at your argument, yes.
I'll just make one further brief point on this issue about mistake and objective justification, which is that a general principle that mistakes by public authorities should not be replicated absent conspicuous unfairness cuts both ways in this case, because the assurances given to TN Retail were a mistake on the CMA's case in the sense of being inconsistent with principles of legal certainty, or in one of the other ways that's been articulated. But they were also a mistake in the sense that they were contrary to the assurances of equal treatment and to the principle of equal treatment which the OFT was bound to follow as a matter of law and as a matter of its own internal guidance and as a matter of what it had told the parties. And again, my Lord, Lord Mance asked yesterday, if you're giving a benefit like this to one party, why not give it to everyone when you've promised equal treatment? And the answer given was that it was a mistake. Well, to pay Summerfield and Gallaher in those circumstances on the same basis as TM Retail, the CMA says, would be to replicate the mistake that was originally made by the giving of the assurances.
Yes.
But we say that not to pay them is to replicate the mistake that was embodied by the giving of assurances to one party and not to the others in breach of the principle of equal treatment. So if there is a principle that mistakes by public authorities ought not to be replicated in general, then that doesn't establish the CMA's case. My Lords, unless there's anything further, those are my submissions on behalf of Cooperative Group.
No, thank you very much indeed. Yes.
Endeavour to be brief in reply. I'll take the sort of key concepts that have been discussed in turn, if I may. The first is the notion of equal treatment. Lord Panic very fairly said that he's not looking for any sort of enhanced standard. That's obviously correct. The fact that the OFT indicated that it was applying equal treatment principles didn't alter that standard. The question simply remains whether a difference in treatment between persons for the purposes of this ground who we're treating as comparable, a difference in treatment is objectively justified. My Lord, Lord Carnwath asked about DeSmith and citations of authority. Lord Panic has produced the Chung authority, which is frankly, in terms of this case, rather limited in its use, and I think Lord Panic recognises that, given the difference that you're dealing with in relation to a test case situation. If it is of any assistance, though, just for your notes, in the Middlebrook Mushrooms case, which is in Authorities Bundle 2, tab 21, at page 1481, that case of Chung and the principle is cited, and there is in fact reference to it being referred to in the 5th edition of DeSmith. By the 7th edition, it's descended into a footnote.
Just give me the page number again.
1481.
Thank you.
Middlebrook Mushroom is rather a nice case, but it's really sort of irrationality.
Yes, it is. I'm not taking the court to it because
I mean, the trouble is we get all, I mean, what I tried to do in the United Policy Group case is try and sort of pull apart some of these.
Yes.
So lots of us have had a go at this over the years, and we've produced different ideas like conspicuous unfairness and abuse amounting to, and so on. I mean, it seems to me there's a clear line of authority, legitimate expectation, that where you have an assurance given to a definable class of people, then you shouldn't go back on it without objective justification.
Yes.
Here the problem is you haven't got an assurance given to a definable.
That's right.
So you then have to go back to concepts like conspicuous unfairness. But as I understand what Lord Justice Simon Brown was saying, he was relating that very much to the facts of that case, which was, again, effectively irrationality, and he uses the language of Lord Diplock from defining that. So
well, that's true. And I quite recognise the comment made by my Lord Sumption yesterday that effectively what we have done is said, look at this in 3 stages. Does the equal treatment principle apply? Is there a difference in treatment between people in a comparable position, in which case, prima facie, you've got a breach, but is there an objective justification for that? And our account, of course, is there's a general principle that you shouldn't replicate mistakes on the part of a public authority. It is a general principle, it's not absolute, and indeed that is the flaw in part in Ms Boyd's submission. We do recognise that when you're looking at whether or not something is an objective justification, not all mistakes are equal. We recognise that, and it's for that reason that we emphasise that in this case, the relevant mistake is salient, because what it does is it undermines principles of finality and legal certainty. But even then, we recognise that there may be circumstances where broader considerations of unfairness, we have added the adjective conspicuous. We recognise that it's difficult to precisely define. But what we're saying is that even if you have a good objective justification, there may still be circumstances, albeit that we see those as being extreme cases, where you would say that the mistake nonetheless has to be replicated. Now, we've taken it as a three-stage analysis. Lord Sumption suggested, well, this is considering perhaps all of these issues in the round and considering the circumstances. We can see that. We've tried to apply a degree of structure to it, in part because of the way that the Court of Appeal approach these matters by reference to legitimate expectation. But we recognise that in some ways one can see this as considering all of the circumstances, the nature of the mistake, and whether or not there is serious unfairness. And we do say serious unfairness here because if you do have a good public interest justification for non-replication of mistake in a particular case, then it will need to be more than just general unfairness in place, because of course in every situation you're dealing with this sort of analysis, the starting point is that prima facie it looks like there's unfairness because you've dealt with comparable situations differently. Indeed, one of the flaws in Lord Panic's submissions, where he says, well, if you're saying if there was unfairness in 2008, you simply can't justify that unfairness in 2012, you end up in a situation where it's very difficult to understand how you can correct serious mistakes by public authorities, because we see from the case law that there's always a sense of prima facie unfairness in these cases. If we take the grade boundaries case, as Lord Justice Elias said, prima facie it's unfair if you treat students coming to do the same examination as subject to different sorts of grade boundaries. But then he goes on to say that maintaining grade standards is an objective justification. And then he says, but does that result in conspicuous unfairness? No. So it's for that reason that we structure matters as we do. We accept that there's an equal treatment obligation in this case, whether it's by dint of the terms of Crest-Nicholson or because of the undertakings and statements made by the OFT in this regard. We've heard a lot from Lord Panic and from Miss Boyd about the fact, particularly in relation to the terms of the infringement and penalty, that the OFT was repeatedly stating that it wanted to apply that equal treatment. That simply goes to reinforce the nature of the mistake that was being made. And as I say, for Lord Panic to say that what we're doing here is to rely on our own breach of the principle of equal treatment is just a wrong characterisation. We say the principle applies, we treat the respondent for these purposes as comparable to TMR, and therefore there is a difference of treatment which might be said to be prima facie unfair, but must we replicate the conduct or consequences for TMR to the respondents pursuant to that principle? And we say no. So it's not that we're relying on a breach. We're saying that even though the principle requires treating like cases alike, it doesn't stop there. It only requires us to do that where there's no objective justification for doing otherwise. And when it comes to the consideration of that objective justification, we do recognise that there will be an assessment and a balancing carried out, and we do say that the public authority doing that does have a degree of discretion. Obviously, when we're in the territory of questions of fairness, we recognise that in the end courts take decisions. But when we're talking about questions of those sorts of balancing exercise, we do say that the regulator should be given a degree of discretion. We certainly say that it is not for the Court of Appeal to be overturning that by reference to its own factual findings in relation to matters that were not canvassed at first instance, in relation in particular to questions of whether or not the mistake could or should have been corrected at times in 2009 or 2010. Indeed, it is notable that in the judgment, going beyond objective justification and even considering issues of fairness, in the judgment of Lord Bingham in Unilever, it is recognised, Authorities Bundle 2, tab 26. I'm sorry, that must be Authorities Bundle 3, tab 26. Page 1721. No, it is not. It's at 1719, a D to E. You'll see a quote from Lord Templeman in Preston, recognising, at least in the context of the consideration of revenue cases, that proper regard should be had to the position adopted by the commissioners in relation to those matters. I don't, of course, seek to suggest that fairness is ultimately a matter of discretion. It's clearly a matter of final decision by the courts.
Well, how far do you mean final decision? I thought a moment ago you said this was a balancing exercise, which is, for the first instance, the public authority. So, decision within parameters set by the court.
Yes, I think that it has to be. I think that's the way that one deals with it. I'm not going to stand here and say that in relation to questions of fairness, courts are not the ultimate arbiter of that question. The issue is whether or not regard should be had to the balancing exercise that is taken into account by our regulation dealing with these matters, and we say yes, and particularly when you're dealing with objective justification issues, that must be the case here. Turning then briefly to the objective justification itself, as we've made, I hope, clear, the objective justification is based on the principle that mistakes should generally not be replicated. And just to untangle some of the references made by Lord Panic to finality and legal certainty, our position is, as actually neatly summarised by Lord Briggs in relation to our position yesterday, the objective justification is the mistake, where a mistake itself undermines finality and legal certainty, it shouldn't be replicated. That is the objective justification here. And it's worth emphasising that that issue arises not in relation to the entry into the ERA itself, but by effectively indicating to a non-appellant that the non-appellant can get the benefit of appealing without actually appealing. And what we say is that the scheme for statutory appeals ensures legal certainty and finality. Either you appeal or you're stuck with liability or penalty, depending on what appeal you want to take. And if you don't challenge either of those, then you're stuck with them. If you do decide to challenge either, you can take your chances. And the importance of that is emphasised in a series of cases. Wood pulp is one. Wood pulp is relied upon in particular because what it is saying is very clearly, as adopted in domestic case law, that appeals by individuals that are subject to a competition decision that concerns a number of parties, an appeal by one party is not in any way relevant or determinative as to the position.
I think we probably got there.
Yes.
I know.
I thought as much, but I only raise it because Miss Boyd was suggesting that somehow there was no mistake here given the terms of wood pulp because a discretion would exist, or we were not saying that these matters were ultra vires. We say that's not the important consideration here to be drawn from Wood Pulp or Carter or Lindham or indeed the Court of Appeal's own out-of-time appeal in these cases. So that's what the assurance undermined. It did also undermine and would undermine the proper operation of the ERA scheme, as my Lord Sumption has pointed out. But one must recognise that it's the appellate system that is being protected here. Entering into an ERA might change your risk arithmetic, essentially, for a potential appellant. But the ERA, as I say, doesn't undermine those fundamental principles of legal certainty. If you're an ERA signatory, indeed, as there was, then your risks of appeal might be a bit higher, your penalty discount could be lost, but you could still bring that appeal. There is nothing disrupted in the appellate scheme. And so we're not saying that the position is that you're absolutely prohibited in relation to these matters from taking these particular points. We're not relying on an ultra vires argument in relation to these matters, but we say that it is based on an error that leads to unprincipled results, and that non-replication of that is an objective justification. As the suggestion made by Lord Panic, there'd be no greater impact on finality or legal certainty by making the payments in lieu of penalties to the respondents, having done so in relation to TMR. Well, we recognise that the mistake in giving the assurances did undermine finality and legal certainty, and we're saying precisely that shouldn't be replicated. And as to the reference to Mr. Philip Collins' evidence at paragraph 42, that's MS 277278, suggesting somehow the chairman of the OFT at the relevant time was suggesting that he's supportive of that analysis is simply wrong. He was explaining how the OFT sought to extract itself from the difficulties it was in whilst minimising further damage. It was damage limitation that was being dealt with here. Just briefly, in addition, on the evidence in relation to mistake, the court has well in mind the point that this is plainly not a policy. Indeed, Miss Branch makes clear she didn't discuss matters with policy colleagues, as was observed in passing yesterday. The question that was being raised by TMR was in general terms, and the evidence is much more consistent with simply a statement of what the OFT officials wrongly thought was the appropriate legal or administrative approach at the time. I would just take you to one paragraph in relation to the evidence of Mr. Christofides. It's in the core bundle MS 207.
'207.
301. I apologise. I'm grateful to Mr. Henshaw. 301. And the paragraph I just wanted to take you to is actually at paragraph 21. Yes, at page 307. This is just his description of the discussion at that July 2008 meeting. I just asked the court to just review that paragraph. And I'd shown you paragraph 14 yesterday. And you can see in paragraph 14 that insofar as Mr. Christofides was thinking about these matters, he was making a clear mistake as to law. He was saying it would, in the 5th and 6th lines, if one of them succeeded on appeal in showing that they'd not entered into an infringing agreement with the counterparty, it would follow that there'd been no infringement. Now, Lord Panic emphasises that on the very same day, the OFT, indeed Mr. Christofides, was amending the infringement terms for the ERA potential signatories. Yes, they were. That was what they were focused on. It simply goes to illustrate what mistake was being made here, and it simply suggests that in relation to the TMR exchanges, the officials did think that they were responding with their view on administrative practice of the law. It's not the term of any deal, it's not the term of any inducement. And I've dealt with Lord Panic's suggestion that there was ample opportunity to correct, which, to be fair to Lord Panic, he says this court is not in a position to revisit those matters, and they were not canvassed at first instance. Just turning then to issues of fairness, the situation is that the respondents got what they bargained for with the ERA and decided not to appeal. There is no unfairness to them, adjectival or otherwise. Having not appealed, they're being held to the consequences of that decision. They made their decision with their eyes open. They were well advised. Plainly, they didn't rely on statements made to TMR. Of course they didn't. Insofar as they say, well, we relied on equal treatment, the answer is, well, that's a different sort of reliance here. The relevant reliance is on whether it affected your decision to appeal. That's what caused the problem for the OFT with TM Retail. That's not applicable to the respondents. And in addition, for the reasons given, equal treatment just doesn't mean that all statements, even if mistaken, must be replicated. So even reliance on the principle of equal treatment is not such as to enable the respondents to have any good claim here. Lord Panic referred on a number of occasions to Papinet, and in particular paragraph 28 of Papinet, which quotes Lord Hoffman in Bankholt, and he says, well, detrimental reliance is not necessary to found a legitimate expectation claim. Well, we accept that. That isn't the point here. We have no issue with that formulation. What we say is that detrimental reliance is relevant to questions of fairness. And indeed, if one looks at that quote, that is precisely what is actually said in it. If we could just go back to paragraph 28 of Papinet, Authorities Bundle 2, tab 16, at page 1305. Of course, this is in the context of legitimate expectations, and we recognise entirely Lord Carmen's point that this is different from legitimate expectations. We say you certainly can't be better off than if you'd had the direct statement made to you. If one looks at the legitimate expectation position, halfway down the quote, it's not essential that the applicant should have relied upon the promise to his detriment, although this is a relevant consideration in deciding whether the adoption of a policy in conflict with the promise would be an abuse of power, and such a change of policy may be justified in the public interest, particularly the area of what Lord Justice Laws calls the macro-political field, and goes back to Begbie. So our point is not taking issue with the formulation of the test for legitimate expectation, but we do say this issue of detrimental reliance is relevant in the context of the consideration of any assessment of fairness. And just in this regard, it is worth pointing out that Lord Panic did very elegantly gloss his own evidence in relation to why it is the respondents themselves didn't ask. If I could just ask you very briefly to turn up in the core bundle at MS 244, a statement of Mr. Bingham. I think Lord Panic referred you to paragraphs 8, 14, 16 and 20. The paragraph I would just invite the court to read is paragraph 15.
And I think we've seen something like that before.
Well, I'm not sure.
Not in this paragraph.
No, it may well be. In passing, I mentioned, I think, Ms. Taylor's evidence 251 at paragraph 17.
What's the point you're drawing from that?
The point is simply that, in fact, the situation is
Yes.
that in not asking for the assurances, actually, what becomes clear is that those acting at least for Gallaher seem to have quite a good appreciation.
Well, they didn't think they would get them because it would
Yeah,
make sense.
well, because they understood. It may well be that they actually understood the law rather better in these circumstances.
Those who understand do worse than those who don't.
Well, I don't think that
Never mind,
would be
don't
the
need-
watchword.
don't need to comment.
Yes. But the point is a simple one, that actually when we're talking about questions of unfairness, the people in question appear to have had a reasonable understanding of what the law actually was. The fact that the OFT then makes a mistake is neither here nor there in those circumstances. There was a citation from Argos where Lord Panic referred to the fact that manifest injustice didn't need to be shown. Now, I think it's important that paragraph in Argos, in paragraph 280,
Reference.
was Authorities Bundle 1, tab 3, at page 827. That was a case in which there was a concern about equal treatment, and there was no objective justification for the equal treatment. And what's being said there is, if you've got no objective justification for the equal treatment, there's not another... For the unequal treatment, I'm sorry. For the unequal, there wasn't an objective justification for the treatment in question. That in those circumstances, one didn't need to have a manifest injustice test in addition. That's a very different situation from that which we're dealing with here. The essence of our case is that the assurances wrongly made were ones where there was an objective justification. And in essence, what we say is that what the respondents are seeking to do here is rely upon those assurances wrongly made and say they should benefit from them too, and that rejecting this proposition is somehow unfair. We do not accept that. Those are the core submissions in relation to the objective justification, what we've referred to as ground 2. I will pick up briefly ground 1, which is our comparability ground, very briefly. In some of Lord Panic's submissions, he mixed our ground 1 on comparability or lack thereof with ground 2. We do refer to detrimental reliance in both grounds, but in relation to ground 2, the objective justification ground, as I've said, all we are saying is that it is an ingredient in the consideration of questions of unfairness. In relation to comparability, what we say is that absence of detrimental reliance may well here be an entirely good reason why you do not consider these two groups, TMR on the one hand and the respondents, as relevantly comparable. And the reason we put it in these terms is simply that we, as we've explained, what we know is that the respondents made a decision not to appeal without having had any assurance. And we say that they cannot now contend that if they'd had received such an assurance, it would have been causative of their decision not to appeal. That's the way that we put the case in relation to comparability. In other words, they can't now say they would have relied upon those assurances in order not to appeal, as TMR was able to do, and because it was able to do that, created the difficulties in relation to a potential appeal out of time in respect of which a settlement was reached. We say that's a material difference. We cited in our written materials the Healy-Hutchison case, which specifically recognises that positions of reliance between, in that case, taxpayers, was relevant to deciding whether or not they were comparable. And we in those circumstances, consider that there is a lack of comparability as between the two sets of parties. In addition, in relation to our comparability case, we emphasise that the comparison here is being drawn against TMR, when in fact, when fuller consideration was undertaken, actually the response was not as per the assurances to Party A or to ASDA. We say they are the more relevant comparators, and in reality, if there had been any further consideration of these matters at the relevant time, that would have been the relevant outcome. So that deals with our ground one, the comparability issue. There are just a couple of housekeeping points, if I may, on questions that were raised yesterday. In relation to the questions about the powers of the OFT and now CMA to enter into ERA arrangements, the provisions that have been provided by Lord Pannick governing the power to investigate and take infringement decisions and to impose penalties are the basis, as I indicated yesterday, for the power to carry out the ERA exercise. There have now, following the Enterprise and Regulatory Reform Act, been certain changes made from 2014 that specifically enable rules to be made in relation to settlement processes undertaken by the CMA. I haven't provided copies of those because, of course, they fall outside the scope of the period we're dealing with here, but I just note that. But I think there's no disagreement on those issues. As to the jurisdiction of the tribunal, which was raised, again, I don't think there's any dispute between the parties on that. The jurisdiction of the tribunal to hear appeals in relation to infringement decisions is provided for in Section 46 of the Competition Act, and further provision is made in Schedule 8 in relation to how you bring a claim, and it is clear that those are full appeals, merits appeals, rather than simply being judicial reviews. And furthermore, as in line with Woodpulp, the approach that is taken there, in line also with Morgan Crucible, is that it is individual decisions that are the subject of appeal and decision in relation to the appellant party. The final point I just wanted to pick up was on Section 60. Section 60 that was referred to yesterday. As to the ambit and scope of Section 60, I think it is important just to note, it may not be germane to the court's judgments, but it is not accepted that the Section 60 provision that imports EU law and EU principles carries across EU law into procedural matters. It's of course accepted that when you're looking at substantive infringements or indeed levels of penalty, or rather the methodologies being adopted, such as are substantive matters, principles of the EU law will be applied, but it is important not to overextend its effect. That's particularly important because there are a range of differences between the procedures that are adopted by the European Commission and those that are adopted by the domestic authorities. And if Section 60 were to be treated or interpreted too broadly, that could create difficulties as to the appropriateness of domestic procedures. So it's simply, in the context of a discussion that was had in relation to Section 60 yesterday, really a plea that that is a discussion, the scope of Section 60, that perhaps could wait for another day because it could have further ramifications for matters concerning the prosecution of investigations in domestic authority proceedings. As it is, it's not clear that matters in any way for the determination of this particular case, given its circumstances. Unless I can assist the court further, those are our submissions in reply.
The court's very grateful to all counsel and those who prepared the case and will take time to consider its judgment. The court's adjourned.